Lordship, please.
What is section 9 for? What page is it? PDF?
Yes,
320?
1.
Yes. What is 9
Now,
for?
9 is grant of driving license. Now, if your Lordship has 9.4 straight away, where the application is for a license to drive a transport vehicle, no such authorization shall be granted to any applicant unless he possesses a driving certificate issued by a school or establishment referred
This
to.
is the way it's shown us.
Yes. Now, I just want to make one point about it. Your Lordship will notice the use of the word authorization. It doesn't say license, because the section itself is about license, grant of license. Now, this is pre-1994. This subsection predates the 1994 amendment. So section 10 at that stage did not have a license for driving a transport vehicle. It only said in section 3 that whichever category your transport vehicle fits in, you will have to have an authorization granting you to drive a transport vehicle. So this fits in with my construction of 3.1. Namely, if you want to drive a transport vehicle, irrespective of what category it fits in, just a license of that category is not enough. You must have an additional authorization to drive a transport vehicle. And this can't be given unless you have a certificate, driving certificate issued by a school, driving school, which is not required for light motor vehicle, which is not a transport vehicle.
Yes.
Now, I just want to make one more point, and that is again relating to section 10. Your Lordship has seen that Mukund Devangan says that because a transport vehicle is included in the definition of light motor vehicle, therefore a license to drive a light motor vehicle shall include the license to drive a transport vehicle.
Right.
Now, the same reasoning applies to road roller, because light motor vehicle also includes a road roller which is less than 7,500 kilograms.
Right.
Now, just consider, road roller was there in section 10.2 initially also, 10.2I. It's still there, was there initially also. Therefore, if you carry the logic of Mukund Devangan, if you get a license to drive a light motor vehicle, you can drive a road roller also, so long as it's below 7,500 kilograms.
But this will be much more than that.
A road roller drives totally differently than a normal car. Turning it, etc., is all going to be totally different. Now just have a look at section 9.3. Before you get a driving license, you must have a test. If the applicant passes such test as may be prescribed by the central government, he shall be issued the driving license. Now this test, your Lordship will find, Rule 15 says, Rule 15.2.
Which provision was this?
9.3.
9.3. So before you get a driving license, obviously you have to pass a test.
Yes.
Now, what vehicle do you drive for the test? That is prescribed in Rule 15.2. Page 443. The test of competence. Does your Lordship have that one?
Yes.
The test of competence. This is under the heading driving test. The test of competence to drive referred to in subsection 3 of section 9 shall be conducted by the licensing authority or such other person as may be authorized in this behalf by the state government in a vehicle of the type to which the application relates. Now, supposing your application is for a light motor vehicle. You go in a Maruti 800 car. You pass the test. You don't drive a road roller. Can it be said now you're authorized to drive a road roller? Even though that's a totally different category under 10.2. If you follow Mukund Devangan's logic, then you can even drive a road roller now. So surely, if you want to get a license for a road roller, you will have to be tested on a road roller of the vehicle of the type to which the application relates. So
Right.
therefore, another reason showing how the logic in Mukund Devangan is totally flawed. And again, reiterating, this will be covered by that Generalibus Specialia derogant. Namely, if something is there specifically, it will be deemed to be excluded from the general.
What else now?
Yes. Now, Lord, just one very quick point, and that is, Lord, possibly the one thing that may have weighed in the mind of the court while deciding Mukund Devangan possibly could have been that the insured may be benefited if the insurance policy is still valid, despite the fact that it's not specifically authorized to drive a transport vehicle. What they didn't notice is that this will jeopardize other road users. Namely, if you permit somebody who has just a light motor vehicle license and permit him to drive a transport vehicle, 7,500 kilos is actually quite large. I mean, in the normal car, a Maruti 800 is less than 1,000 kilos. Reasonably large, like a Fortuner or something, is about 2,000 kilos. So 7,500 would be a medium-sized bus. Now, to permit somebody to drive a medium-sized bus, even though he has been tested on possibly a Maruti 800 car, would jeopardize other road users. So, while on the one hand, you may be saying that, all right, this will benefit some insured who would otherwise lose the benefit of that insurance. But on the other hand,
But you're speculating on the reasoning, possible reasoning.
possible.
That is
Yes,
not
yes.
indicated.
I'm
in
only
your
saying, Lord, that in case this issue arises, the fact of the matter is that, of course, we have to go purely by the act. But in sort of benefiting some persons who may otherwise lose insurance, we can't jeopardize other road users by permitting people who would otherwise not be competent to drive that vehicle, especially in view of the specific exclusions under 3.1, etc. Now, Lord, just one thing I want to say, which may not be related with the outcome of this case, and that is that amendment of 1994. If your Lordship sees, Lord, all those medium, heavy, etc. have been removed, and they have all now been brought under the umbrella of transport vehicle, irrespective of the weight. Now, transport vehicle could be a small, one of those three-wheeler goods carriers, which may be reasonably light and very small. It may be something with a trailer carrying a container, which is huge. Now, your Lordship has seen under section Rule 15, section 9.3 and Rule 15 that you are tested on the kind of vehicle that you are applying for. You are applying for a transport vehicle now. You may be tested on one of those small little things, something which is colloquially called the chota hathi. I don't know if your Lordship has heard that phrase. The very small three-wheeled goods vehicle. You may be tested on that, and then you become licensed to drive a huge trailer with a container. Now, earlier that was not the case. So this amendment may be ill thought of, because you may be tested on a very small vehicle and now you're permitted to, of course, it doesn't make any difference to our case. Well, our case doesn't depend on that. Just a small aside that I'm pointing out to your Lordship, Lord, if your Lordship feels that something needs to be said about that.
Thank you, Mr.
I'm very, very grateful to you.
Thanks, Mr. Bhushan. Thank you. Yes, Mr. Kaul.
Just one last thing, Lord.
Yeah, sure.
And that is, question that may arise is, why do you define light motor vehicle with all these different classes? And the answer may be, Lord, in Rule 34. Because different fees are payable for a trade certificate based on whether it's a light, medium, or heavy. Rule 34 read with Rule 84 and the table with Rule 81, which is the fees chargeable. This is for a trade certificate. Very grateful to you, Lord.
Yes, Mr. Kaul.
May please. Ultimately, the issue is not whether transport vehicles are included in the definition of LMV. The issue is whether the holder of an LMV vehicle, simpliciter, is entitled to drive all vehicles within the scope of section 2 subclause 21 without any specific endorsement, without any application, test, eligibility, age requirement, medical certificate at all. So simply because you have an LMV license is enough for you to drive all vehicles under section 2 subsection 21 is the mistake, with all respect that I say, is committed in Mukund Devangan. And this error, my lords, occurs because what the court does is to say that under section 2 subclause 21, LMV includes transport vehicle, and even after the amendment of section 10 subclause 2 subclause D, LMV still stands as an independent category, quite apart from the transport vehicles which consolidate heavy and medium vehicles. Thus, simply by having an LMV license, you can drive a transport vehicle within that category. That's where the error lies. Completely ignoring, my lords, that the light motor vehicle definition under section 2, subclause 21, is a broad definition based on weight and includes all kinds of transport vehicles. It's a general definition which is weight based. But that does not imply that the licensing regime or the eligibility restrictions for all kinds of LMVs remain the same. That's the error. It's a general description, a definition which is weight based. But to say that the entire licensing regime, all the eligibility conditions now need to be that of an LMV and not of a transport vehicle is the most fundamental error which is committed in the judgment in Mukund Devangan. And my lords, which your lordships have now repeatedly heard, and also observe. The issues involved of public safety, of much longer hours, duration, hazardous goods, interaction with far more passengers, congestion, many of those issues come in. Wide transport vehicles and their eligibility conditions, the licenses to be taken, medical certificates, all are put as stringent conditions there. Those are the essential differences. Now, even, my lords, as far as the forms are concerned, because please have Form 7 of the compilation which Mr. Dave gave at page 881, Form 7.
Sir, may I have your lordship's leave? No?
Yes, yes.
And it's this compilation which Mr. Dave gave in the morning. Please have page 881.
Different form with.
My lord, sir, page. Let's kindly see even issue date, validity, NT, validity, transport.
Yes.
Provided there. Please have the other page, 882. Class of vehicles, there's a two-wheeler, there's a car, and it all says light motor vehicle, transport, and then again categories, please see NMV, could be a transport or could be a non-transport.
Yes.
The categories are provided there.
Right. That is
Now to say that I have an LMV license and thus I'm entitled, even I was looking at my old license, which was 2018, before the 2019 amendment came in. There it simply said LMV, but below it, it said validity T, in my case, non-applicable, validity NT, and the date was different, non-transfer. So this has inherently always been there given the scheme of the Act. Now kindly see this with the form also in Form 4 that used to be there, Form 6 which used to be there in Mukund Devangan. Please have page 78 of this very compilation.
This is also.
Your Lordships, be kind enough to have page 79.
We were just talking about the stick shift age, the stick shift gears.
Yes, yes, yes.
Today's generation will not know what they are.
Everybody's used to automatic.
But things have a knack of coming back. We never know. Someday it may become the fashion again to drive those cars,
Like the turntable.
like the turntable. Would your Lordships be kind enough to have page
Turntable has become
79? Page 79. Now, this was the form in Mukund Devangan, my lords. And please see somewhere in the middle, a motor vehicle of the following description. First, the descriptions are given, and then a motor vehicle of the following description, license to a driver or motor vehicle other than transport vehicle. And on the right side, license to drive transport vehicle. And then below it, authorization to drive transport vehicle. So there has always been a specific authorization.
We had seen that actually earlier.
Now, my lords, I'll quickly just sum up 2 or 3 provisions and the crucial errors as I see in 3 or 4 paragraphs, and I'm not going to trouble your lordships with the paragraphs again. Para 17 of Mukund Devangan, my lords, as I had respectfully submitted to your lordships, commits the error of saying that because under 2 subclause 21, LMV includes the transport vehicle, and since under section 2 section 10 subclause 2 subclause D, it still retains its position under
That you said, yes.
Thus, a license is enough. The next error is para 21, my lords, where the court goes on to say that an amendment would be required to bring the transport vehicle outside the category of LMVs. And since that is not done by the legislature, a transport vehicle of a light motor category does not require a separate registration. Now, one of the 2 fundamental errors in that are that no one is denying that transport vehicle below a certain weight is including in the LMV category. The problem doesn't lie there. The problem lies in your applying the same licensing regime and eligibility criteria to transport vehicles, not of a certain weight being categorized under the LMV category. So there is no amendment required. It can surely be because LMV below a certain weight covers many things, covers many kind of vehicles. Thirdly, my lords, again in para 21, the error is that the intent behind the 1994 amendment is again referred to say that they retain their separate positions. Thus, a category of a transport vehicle which covers heavy and medium is separate from the category of a transport vehicle which covers LMVs.
Yes.
That's the third point given.
What is the third point?
The third point given is, my lords, that the intent of the 1994 amendment
Yes.
was to combine what used to exist in 10 pre-amendment, that is category E to H, in order to create 2 separate classes of transport vehicles, one covering heavy and medium, and the other covering vehicles weighing less than 7,500 kgs. Completely ignoring the fact, my lords, that knowing fully well that LMVs include transport vehicles below 7,500 kgs under section 2 subclause 21, the legislature still retains LMV as a category and retains transport as a blanket category. Now, if the legislature intended that this will only cover heavy and medium, the transport, it could have specified it therein. It doesn't do that. And rightly doesn't do it because eligibility conditions, requirements are all different. So all that is done is a simplification of procedure. All transport vehicles at one place, light motor vehicles at one place. Now to correlate it and say 221 LMB covers transport and thus nothing requires is the error. Next, my lords, is para 25. Which completely ignores section 14 of the Act, where different validity periods are provided. And it again embarks and says that this is only in the form. The form cannot override the statute. And these validity periods will only apply to heavy and medium transport vehicles as contained post-amendment to section 2 subclause DNA. Completely ignoring 14 of the statute, which deals with validity periods for various provisions, for various class of vehicles. Now, my lords, if this judgment is seen as it is, it has the effect of completely obliterating the requirements regarding user or intended use. And I'll end, my lord, with those 4 or 5 statutory provisions again. Because as I see it in all humility, the Act is user-based, is utility-based. It's the usage which is to be given importance. It picks up a section, the weight contained therein, and completely obliterates the requirement of usage. My lords, lordships have again and again seen these sections, but just 4 sections, if your lordships were to have for a minute. And I'll just run through those 4 sections and I'm done. Section 2, my lords, for a minute. Driving license means the license issued by a competent authority.
Section 2, which is the provision?
Subclause 10, page
Yes.
316.
Yes.
Mr. Dave's compilation.
Yes, driving license.
Driving license means the license issued by my lord the Chief Justice.
Yes.
A driving license means the license issued by a competent authority under Chapter 2, authorizing the person specified therein to drive otherwise than as a learner a motor vehicle or a motor vehicle of any specified class or description. Then Section 2, subclause 21. Light motor vehicle means a transport vehicle or omnibus, the gross vehicle weight of either of which, or a motor car, or tractor, or road loader, the unladen weight of any of which does not exceed 7,500 kilograms. Now, my lords, Section 2, subclause 47, which is on page 318. And I should have given the page. Actually, Section 2, subclause 21 is on page 317, and Section 2, subclause 47 is on page 318. Please have Section 2, subclause 47. Transport vehicle means a public service vehicle, a goods carriage, an educational institution bus, or private vehicles. Now, my lords, each of these, the public service vehicle is defined in Section 2, subclause 35. Private service vehicle is defined in Section 2, subclause 33. Goods carriage is defined in 2, subclause 14, and educational institution bus in Section 2, subclause 11. Now, my lords, each of these categories, please see the terms they employ. The terms employed are used, adapted to be used, adapted to be used, constructed, or adapted for use. Clearly showing that the category of transport vehicles is entirely based on the use of the vehicle and not on the weight of the vehicle.
Used, adapted to be used. You said constructed?
Used, adapted to be used or constructed or adapted for use. Each of these are clearly based on the use of the vehicle, not on the weight of the vehicle. And as that example has been repeatedly given to your lordships, there could be a vehicle of less than 7,500 kg with hazardous goods, school children being ferried. So many instances, long hours on the road. So do we obliterate all those restrictions and conditions as contained in the statute? Then, my lords, the next section is section 3.
Since it's user based, not based.
Section 3, subclause, section 3 on page 319. No person shall drive a motor vehicle in any public place unless he holds an effective driving license issued to him authorizing him to drive the vehicle, and no person shall so drive a transport vehicle other than a motor vehicle or motorcycle hired for his own use or rented under any scheme made under subsection 2 of section 75 unless his driving license specifically entitles him to so to do. Read with my lord section 10 for a minute, and then I'm done as far as the statutory provisions are concerned. Do we have them? No, we don't have that. In fact, my lords, I'll also hand over the pre-amendment section 10 because that may be of some assistance to your lordships to say that earlier, my lords, the category of light motor vehicle remains. E to H, as they earlier were medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, and heavy passenger motor vehicle. That E to H were combined to make them into transport, which came in the new.
Right.
And that which I respectfully submitted is can't be read to mean that light motor vehicle has been retained. And since under 221, it includes transport vehicle, a new category is carved out of a light motor vehicle, which is a transport vehicle of less than 7,500 kgs, not requiring any of the things of eligibility, etc., which are required to be done, which could not be so. Lastly, my lords, a few judgments I'll just leave with your lordships, which have already taken the view that we are today canvassing before your lordships. And I just leave those two judgments with your lordships. Just two judgments. These two, right? My lords, one is New India Assurance Company Limited versus Prabhulal, 2008, Volume 1, SCC 696, paras 42 and 43.
Whose judgment is that?
Manoj, it's part of the compilation, page 118 to 133.
Okay.
And then second is Oriental Insurance Company versus Angat Cole, 2009, Volume 11, SCC 356, paras 13 to 16. This is in the compilation, pages 139 to 146.
And the first one?
First one was in the compilation, pages 118 to 133.
Yes.
And both, my lords, before Mukund Devangan had differentiated between the two kinds of licenses, the two kinds of classes of vehicles, the eligibility requirement, both had dealt with it.
Yeah.
Now, my lords, I am not revisiting, since your lordships have repeatedly seen all those conditions on age, qualification, that you must have even before a learner's as a transporter, you must have a license, all those conditions which have been repeatedly shown to my lords.
Yes.
And thus, my lords, to say that an LMV, to end to say that an LMV, merely because it covers on a weight,
Right.
a transport vehicle requires no other requirement to make you eligible to drive a transport vehicle, would be completely contrary to the statute. And as your lordships in ERA and many other judgments have held, the text and the context has to be seen. A purposive interpretation, a harmonious construction is what your lordships will see, and not a interpretation which renders large parts of the provisions odious or obliterates a very important part in the scheme of the act and defeats the object of the act. I'm very, very grateful, my lord.
Thank you. Thank you, Mr. Paul.
I have nothing further to add. I'll take only 5 minutes only. Because one angle, my lord, which may assist your lordships even in arriving at a correct conclusion, my lord. Lord, your lordships would find from the general architecture of the act, the sine qua non or the intention of the legislature under every provision is the safety of the one who drives and safety of those who are affected. The passengers or people on the road.
Yes.
Lord, keeping this overarching parameter or in legislative intent in mind, the act is divided into several regimes, one of which is licensing regime. Section 10. Lord, your lordships would bear in mind, your lordships have been repeatedly shown section 221 that light motor vehicle means transport, includes transport vehicle. But for the purpose of the first regime, namely licensing regime, both are separately provided. Your lordships have not seen that.
Yes.
Under 10(2), D and E, legislature had no necessity to separately provide. It could have said light motor vehicle, which in any case would have included transport vehicle.
Yes.
Then the question would arise, why section 221 provides for a separate weight? What is the significance? What is the statutory importance of the term weight? 7,500 and 12,000 respectively for light and heavy motor vehicles. Lord, that is for a different regime, which my lords would find from section 113. Again,
Yes.
kindly come to section 113 of the Act, my lords. Motor Vehicles Act, my lords. This is another regime, of course, taking care of the safety, but not licensing regime. And that is where, my lord, the weight comes. The state government, your lordship gets one.
So, Solicitor, today you forgot your iPad at home?
I I'll read, my lord. I beg your lordship's pardon, my lord. But I didn't even realize that I'm already continuously committing.
We have to constantly goad everyone.
Old habits die hard.
Yes, I'm so sorry, my lord. Lord, please see section 113. But now I have learned, my lord, under your
Yes.
the state government may prescribe the conditions for the issue of permits.
My learned brother says, when you said I've learned, my learned brother said, under your coercion.
Not coercion, my lord, I wanted to say. My lord, the way I stopped at the word under, my lord, may lead to that, but that was not intended, my lord.
Yes.
The state government may prescribe the conditions for the issue of permits for transport vehicles. Please see, my lord. By the state or regional transport authorities and may prohibit or restrict the use of such vehicles in any area or route. Your lordship knows, my lord, in some of the areas, transport vehicles are prohibited,
Right.
and here comes the weight part. Please see, except as may be otherwise prescribed, no person shall drive or cause or allowed to be driven in any public place any motor vehicle which is not fitted with so and so. No person shall drive or cause or allowed to be driven in any public place any motor vehicle or trailer, the unladen weight of which exceeds the unladen weight specified in the certificate of registration. Lord, there can be an area where there is a prohibition of driving any vehicle which is more than 7,500. Lord, your lordships would find section 114, I am not reading. It confers power on the statutory authority to get it weighed if someone disputes. But please see 115. Here also, my lord, the weight comes, whether my vehicle is a light motor vehicle, which may include transport vehicle or not, but distinction would be that of weight. The state government or any authority authorized in this behalf by the state government, if satisfied that it is necessary in the interest of public safety or convenience or because of the nature of any road or bridge, may by notification in the official gazette prohibit or restrict, subject to such exceptions and conditions as may be specified in the notification, the driving of motor vehicles. Here, my lord, the weight can be the consideration. That motor vehicle, light motor vehicles, except transport vehicles, are not permitted because it has weight of 7,500 and the bridge is in a dilapidated condition. Or any specified road, and when any such prohibition or restriction is imposed, shall cause appropriate traffic signs to be placed or erected under section 116 at suitable places, etc. My lord, then rest are, my lord, supplementary provisions to that. So, my lord, weight has its own importance in a separate regime, but section 10 says, so far as licensing is concerned, we give a separate license for light motor vehicle, and though transport falls within that, we give a separate license for transport vehicles. My lord, my learned friend has, my lord, just, my lord, one last minute. My lord, in my written submissions, my lord, there are some, my lord, your lordships are orally already informed, page 82 of my written submission.
All right, Mr. Solicitor, we'll take a little liberty with you. We'll hear Archana on that part.
Please, your lordship, kindly do
Come
that.
on, tell us, Ms. Dave, what do you have to say? Thank you, Mr. Solicitor. Thank you. Thank you.
Thank you.
Submissions that my learned Solicitor General Senior was showing, my lords, we have attached some photographs. If my lords would kindly come to the submissions of learned Solicitor General, my lords. Annexure A4, my lords.
Final written submissions?
Yes, my lords.
Lecture A4 you want to say?
Yes, my lords. Those are bookmarked, my lords.
Bookmarked, correct.
Yes, my lords.
Okay. Union of India versus Dilip Kumar Singh.
No, it's the final written submissions, page 82, my lords. There are pictures, my lords.
Like this.
Ah,
This
Honorable Chief Justice.
she has got
Here from that.
Malad, so this, Malad, the first picture, Malad can see it's a school bus. And the weight, the gross vehicle weight is 7450 kg. So going by, Malad, what Mukund Devangan says, it means that anybody who's holding an LMV license would be able to drive this vehicle. So, Malad, it is basically the use for the licensing regime. It is the use which is important. As it was also discussed earlier, weight can also be for tax purposes, like my learned senior Mr. Dave pointed out. And also with regard to which road you are traveling, as my learned senior Solicitor General just now pointed out, in section 113, 114 and 115. But Malad, only to see that 221 has to be seen for the licensing regime, in my most humble submission, Malad, is contrary to the statute and rules, as we have already seen.
Yes.
Well, so similar are the other pictures that I have put, my lords. It is again a school bus. The gross vehicle weight is 5,900 kgs.
Should impact the right action.
Well, as when we talk about the harmonious construction of the statute, it means that if, well, you have to read the statute as a whole. So when there is one provision which is going contrary to all the other provisions, then a harmonious construction of the statute with regard to what purpose it is defining. So maybe the definition clauses with regard to the weight, because they are saying that maybe a light motor vehicle can mean a transport vehicle, and they have prescribed a weight. But whereas in chapter 2, section 3 clearly says that it is the use of the vehicle, and the second part, whereas the second part is in fact a negative covenant, which is saying that you cannot drive a transport vehicle. Well, these are my submissions. I have also Malaj filed another submissions saying the judgments on harmonious construction. Well, additional written submissions. I don't
Not
want to
necessary. You can on the we'll
Let's
check out GPC.
cut out the paragraphs for my lords.
All. Thank you, Mr.
Thank you,
Dave.
obliged.
Thank you. Thank you, Ms. Dave.
Just 3 minutes, minutes. I represent this.
For the
Minutes, I
on
am
the same side as this?
Same side.
All right. For the insurance company or?
not for an intervener, minutes. I represent a society, minutes, which helps road accident victims. And minutes, it's called as the Society Against Drunken Driving. Minutes, my IA number is 133,096 of 23. Minutes, the point that I am making is, minutes, this honorable court has looked at road safety as a fundamental right under part 3. It has specifically recognized it to be a 21 right. And my lords, having recognized those 2 paragraphs of the judgment, my lord, which says that road safety is a part of a 21 right. If you read it as a 21 right, my lords, my submission would be Mukund Devagan on the road, my lords, in real terms, would be an antithesis to road safety, because it completely obliterates section 7, makes it OTOs. Under these circumstances, my lords, section 7 has to be read as a safety measure. My lords, post that judgment, my lords, that is the judgment on Life Safe Foundation, 124A was introduced as a safety measure, where, my lords, people, bystanders who are called as good Samaritans, who help people, my lords, because normally the tendency the judgment recognizes the fact that people don't come to help road accident victims at all because of the consequences they face with regard to investigation and interrogation. They are supposed to go to police station. Therefore, whereas the court had laid down the guidelines and said that till that the vacuum is cleared by a statute or a regime which recognizes the right of bystanders not to be called as a witness, or rather they are, instead of being called as a witness to the police station for interrogation or during court, what they are supposed to send a commission to them, help these people. In fact, my lords, in US, there is some, in UK, my lords, there is something called as a Heroism Act, where, my lords, a person who helps a victim is in fact considered as a hero. And thereafter, my lords, they are given certain special recognition by the society itself, so that this sort of road accidents or in a way, my lord, stopped, or at least, my lord, to extend. Now, your lordship may kindly see that judgment. That is, my lord's 2016 7 SCC 194, which considers it as a part 3 right. 2016 7 SCC 194. Lordship may kindly look at page 208. I just read 2 paragraphs. Your lordship got it, right? 208.
Which paragraph?
55 minutes. 56.
Yes, we saw that.
Yes.
55.
56 minutes. I repeat
56.
56 and then 58 minutes for this. The Department of Road Transport is responsible for framing motor vehicle legislation and evolving road safety standards in India. WHO, my lords, it's also a part of India's international obligation. WHO, in its World Report on Road Traffic Injury Prevention 2004, has projected that by 2020, road accidents will be one of the biggest killers in India. It is also emphasized that in low-income countries, the most common desisting factor restraining the public from coming forward to help victims is the apparent fear of being involved in police cases. There is need to build confidence amongst the public to help road accident victims. Bystanders should not be insisted to divulge their personal particulars or detained in the hospital for interrogation. People are hesitant to render immediate help to the road accident victims. The victims lay wounded on the road for some time till the arrival of police. Delay in rendering medical help in such cases sometimes is fatal. Good Samaritans have the fear of legal consequences, involvement in litigation, and repeated visits to police stations. There is urgent need to tackle these issues. There is need to establish legal framework so that a good Samaritan is empowered to act without any fear of adverse consequences or harassment. Saving life must be the top priority. Several countries have enacted such laws. Now, your lordship may skip over and come to paragraph 57, my lords, at page 209, where they say it's a part of a part 3 right. Lordship got me?
Yeah.
Accident cases require fastest care and rescue, which could be provided by those closest to the scene of the accident. Bystanders' clear support is essential to enhance the chances of survival of victim in the golden hour, that is the first hour of the injury. As per the WHO India recommendations, 50% of the victims die in the first 15 minutes due to the serious cardiovascular or nervous system injuries, and the rest can be saved through by providing basic life support during the golden hour. Right to life is enshrined under Article 21, which includes right to safety of persons while traveling on the road, and the immediate medical assistance as a necessary corollary is required to be provided, and also adequate legal protection and prevention from harassment of good Samaritans to good Samaritans. Therefore, my lord, this contemplates the realistic situation that exists today. And therefore, my lord, this court found that there is a vacuum, brought it within the regime of Article 21. Otherwise, there was a legal vacuum here. Brought it under the legal, within the purview of 21. And thereafter, my lords, this led to an amendment. The lordship may kindly see 124A of the Act minutes. Not an amendment, not a new incorporation. I'm sorry. 134A. Protection of good Samaritans.
124.
134A.
Oh, 134.
I'm sorry. 134, capital E.
Yeah.
A good Samaritan shall not be liable for any civil or criminal action for any injury to or death of the victim of an accident involving a motor vehicle where such injury or death resulted from the good Samaritan's negligence in acting or failing to act while rendering emergency medical or non-medical care or assistance. But he is not visited with any civil consequences or even criminal consequences. a direct fallout of this judgment. And two, my lords, the central government may by rules, your lordship may ignore this, come to, my lords, the explanation of this. For the purpose of this section, good Samaritan means a person who in good faith, voluntarily and without expectation of any reward or compensation, renders emergency medical or non-medical care or assistance at the scene of an accident to the victim or transports such victim to the hospital. So, my lords, this is a safety wall, this is a safety measure. And my lords, if you contradistinct it with section 7, my lords, which, my lords, today, which is totally a non-safety measure, which takes away, because section 6, 7, my lords, clearly makes a distinction. My lord, just visualize the situation where any of us who are having a normal valid license, taking bus children to school, or, my lords, taking a road roller. But these situations are situations, my lords, which fall foul of 140-21, and it should be considered as a safety measure or a, my lords, a safety section or a safety valve section. Semantics do not matter, but the fact remains that section 7, more than the semantics, has a bigger role to play, my lords, seen in the context of Article 21 as well as 124 capital A, my lords. 124 capital A came subsequent to 7. Therefore, it recognizes the principle that the regime has to be strengthened with regard to making it more stronger, so that it's better, easier, safer for the people, rather than section 7, my lords, should not be made.
Thank you.
Deeply obliged, minister.
May it please, Lordship. Lordship, I appear in item number 11, 48 and 51, as circulated by written submissions in item number 11. Lordship, essentially, I'm addressing your Lordships on the issue of the possible scenario if your Lordships hold that the law laid down in Mukund Devangan is not right. I've indicated 3 scenarios, your Lordship. May please have my written submissions, the question of law which I have formulated. May I read, your Lordship?
Eleven,
11, 48 and 51, ma'am.
48.
May I?
Mr. Solicitor, in our section, in the 370 matter, which will start next week,
Yes, sir.
if you can just make sure that the 2 nodal counsel prepare the written submissions, the compilation with continuous pagination.
Yes, ma'am. Of
They'll have to
both
just,
sides.
of both sides, with one continuous pagination. It could be in book form, so that, one book could be, the precedents which are relied upon by the petitioners, other documentary material, likewise for the respondent. But let it all be in continuous pagination.
Yes, yes.
We'll notify guidelines for these matters, because we are also,
Yes, my lord, your lordship, sir.
we are just
Yes.
fine tuning the
But I
guidelines.
today itself, my lord, speak to
The
both
two-
of them.
So that they can sit down and make sure that, where.
We'll sit together and make the pagination so that every pagination tells.
Over the weekend, then, the council is going to open from the other side. Maybe Mr. Ramchandran is opening perhaps. Last time they told us that.
My lord, last time, one Mr. Zafar Shah from Jammu and Kashmir, he opened the arguments, and the next was Mr. Rajiv Dhawan.
Oh, I see. But whoever is opening the arguments, and then those who follow should have that common pagination, so
Yes,
that
yes. Well,
also
we'll
for your
ensure.
side, it'll be much easier.
We'll ensure that. Well, for the respondents, we may have to supplement our written submissions after listening to them. But that doesn't, my lord, it would not come as a last minute, my lord, that 10,000 which your lordship said experience. That's not the idea.
But make sure that both the juniors sit down, the council sit
I'll
down
ensure
and give us,
personally speak to both of them.
and by tomorrow we'll notify the guidelines also, I think.
Yes, my lord, the date is 27th, by
27th.
which, my lord, we are supposed to do that.
Yes.
It would be done, my lord, accordingly.
Right. That will be nice.
Speak to both of, yes, my lord.
I said next week by mistake. It's actually, of course, after that,
2nd August, your lordship.
2nd of August. So there's enough time to make sure that the pagination. Yes.
Yes, Your Lordship. My first question is whether the direction given to insurance companies to pay third-party claims and recover the amount from the owner requires reconsideration in cases where an insurance company has a valid defense under Section 149 2A, Roman 2 of the Act. Now, Your Lordship, this is 150 in the new Act after the amendment. Second, Your Lordship, is whether in the present day scenario, insurance companies, to avoid liabilities towards the insured, are required to prove that the insured was guilty of negligence and failed to take reasonable care while employing the services of a driver. And third, Your Lordship, is whether the law laid down by this Honorable Court in Pappu versus Vinod Kumar Lamba, 2018 3 SCC 208, is in slight conflict with Swaran Singh. Now, Your Lordship, question number B and C, in my respectful submissions, are perhaps the same facets, different sides of the same coin. Essentially, there are two submissions. Your Lordship, the issue of pay and recover. If an insurance company establishes a breach under 149(2), the remedy, Your Lordship, is given the benevolent nature, Your Lordships direct the insurance company to pay third-party claims and thereafter recover from the insured. This principle was doubted by learned two judges, and this issue was referred to larger benches in two different cases. Lordship, may I please have page 69 of my written submission.
But do we deal with pay and recover in this
Yes.
matter?
Why? It will be important initially, Your Lordship, may see if the, no, this is, I say
Not a
that.
part of the reference really. Then for us, nobody else has argued that, and for us
I
to
say
then
this,
hazard
Your
into
Lordship,
this.
under,
If
when
there's an independent reference pending on that,
it's
either,
been dismissed. The question of law has been kept open. The order issuing notice on 31st October 2017 in the present matter, the lead matter, Your Lordship had framed this question. If I may point out, page order dated 31 October 2017. Please have this.
There were more than pending, but
Why do you say that the present reference becomes necessary
Because, Your Lordship,
for answering this
yes,
question?
I say this because if at all it's held that yes, for driving a transport vehicle, you need an endorsement, the remedy would be pay and recover. If there's a breach, I have established it as an insurance company. After detailed investigation, the trial court concludes that yes, there was no endorsement. Then what is the sequitur? There is no liability on me. I pay that liability of third
The
party,
answer
and
to
there
that question would not depend upon the interpretation that we will arrive on section.
on the act.
On the act.
But you say the relief would be
That's a
the
different matter.
pay and recover.
We can reformulate the relief,
fact-based issue.
but then on a pure interpretation of the Motor Vehicles Act, whether a second license necessary for transportation, for driving a transport vehicle or not is the only question that we.
Yes,
need to
question,
decide.
but if you Lordship may please see the 31st October.
Whether, you know, the court should, is entitled to pass a pay and recover order.
Yes.
That
Would
really
not
doesn't,
depend on
it
this
doesn't, yeah,
interpretation.
it doesn't,
No,
it
but
doesn't
suppose-
arise here.
We did not.
Here,
May I
the
just
insurance
point out-
companies say, the insurance companies like you, we've heard Oriental, you're for National. Insurance companies here are clear in stating that, look, that merely because you hold a light motor vehicle license does not entitle you to drive a transport vehicle. The consequence of that would be that where the driver of the vehicle was driving a transport vehicle, though that person had a light motor vehicle license, that would amount to a breach of the insurance policy. What the consequences is not something that arises here.
And also liability is a different issue.
If your
we will
Lordship sees
see at
the order,
that
if I
point
may
of time.
just point out the order dated 31st October
They have been.
2017. Please have this. The order dated
Mukund,
2017.
really speaking, we are considering the correctness of Mukund Devangan.
Right.
And Mukund Devangan is not really, though I heard Devrat yesterday say that we will argue pay and recover, But really, that doesn't arise here.
That's the relief one could get in a third party
But
claim.
that's a matter of relief. That's not a matter of, we are not concerned about
Consider that after this
in an
judgment is
appropriate.
there,
May I just point out?
Is it referred to 5? Is it referred to 3? Oh, now that is over now.
Unless it's over
It's
now.
over. All of them have been
Questions of law-
dismissed. The questions of law have been kept open. But your lordships, when issued notice in this matter, had specifically formulated this question, although it doesn't find mention in the 2018 reference order or the 2022 reference order. May I just point out, read that out.
2022 also.
My humble
It doesn't,
submission
it
would be
doesn't.
that we have not addressed at all on this issue and.
As in
this does
Mr.
not
Solicitor, Mr. Solicitor, a little assistance from you. What do we do about this pay and recover business? Because up to now, in the last one day that we have been hearing, in fact, we are hoping that we'll conclude the hearing today by giving them an hour to address us. Now, this pay and recover, I mean, that has not been argued so far by anybody, and that's not the subject matter of Mukund Devangan.
Yes, Lord. I think nobody has argued because it's not a question framed.
We are not arguing.
And
We were on the different.
the question of law, my lord, it seems is kept open.
Why can't
In a
that be
given
resolved?
case, he can agitate that question, if need be, can get it referred. If your
Twice
lordship
it has
final
already
verdict,
been done.
whichever way it
Twice,
goes,
and they've been
helps the
dismissed.
situation.
As
it
far
has.
as the issue of pay.
See,
and
ultimately,
recovery
look at it
is
this way,
already
pay and recover,
settled.
pay and recover, why do the courts pass that order? The idea is to benefit,
That's right, my lord.
the
Given the
most
benevolent
vulnerable section of society. Mostly these are people, who are on the margins of existence, farmers, laborers.
Also, this
somebody
Swarn
lost
Singh
a
judgment has
child.
settled the legal.
Also, the reason where the
enter
court
into
is
it
not
here as a
able to
five-judge.
fix the liability on the insurance company or the owner. So keeping that question aside, we would say that immediately pay him because the insurance company has the capacity. But then that question doesn't really depend upon the interpretation that we will have
That's
to
right.
arrive on this case.
Your lordship, what would be the ultimate
know why,
relief?
how that
Supposing
is-
if your lordships hold that the law laid down is incorrect, that yes, you are required to hold a
Second
endorsement from a
And
trans-
therefore, you are not liable.
and therefore you're not liable, but
That
you
help,
have,
you will
That
be.
depends on
relief
what
would be,
suppose-
I cannot be absolved. I
It doesn't-
won't be
it's not a
absolved.
equitable.
The courts would still pass because in Swaran Singh's case.
What would still pass is
A
really
pay
an
and
argument on the facts of a given case.
Yes.
Right, but
There is a
that has
gap
been-
between the
The
decision
legal
that
issue
we
is
will have
already
to
settled
arrive.
by the Swarn Singh judgment, my lordship.
So
The
that's
legal
why-
issue is already settled by the Swarn Singh judgment, my lordship, with respect to the pay and recovery.
Scenario.
Yeah.
If I can just address your lordship in 2 minutes, why pay and recover now is not the correct approach, because Swaran Singh was delivered in 2004.
Why it is absolutely necessary. for us
Whenever
to decide
someone
that.
relies upon that Swarna Singh judgment, he may have to argue this and get that issue referred.
It has already been done twice, and it's been dismissed with question of law kept open.
That's the.
Third, for us to take it up.
May I point out, 31st Doctor, if your lordship sees,
Judgments.
the order dated
I'll just point out.
Oh. दिखाओ तो मैं heading to show that order. तुम दिखाओ.
In your compilation or in Mr. Dave's compilation?
Must have kept the question. Where? Which one?
287, 297.
Whose compilation?
The judgment compilation of.
57 is
But my suggestion would be, I'll point out how this may affect, that your lordships can consider framing a question and my lord, left it to be decided on some other day. Please see, my lord, head note A, how my lord, this might perhaps.
297.
297, it's National Insurance Company versus Swaran Singh.
It's not there.
Judgment compilation.
Whose judgment?
Lordship may see.
There is no solicitor's
It's
compilation.
not there in your compilation.
It's there, my lord. It's there in my submission, page 110. My submission, page 110, if you look.
Okay, we take
Your
yours.
lordships have page 33 of
110, no?
our compilation. My lord. I'm sorry, my lord, page 33. Page 30.
Page 33.
Page 33. My apologies.
इसका है 33.
Head note A.
33, ठीक है.
That is for
Head note A. No, I'm not reading the detailed head note. Section 149 2A, duly licensed occurring in section so and so, meaning and construction of, whether different from effective license occurring in section 3. Accident, meaning of and relevance of meaning of to question whether driver duly licensed. Whether a driver duly licensed when, not A is license not held, B fake license held, C license held but validity thereof has expired, D may not affect this, license not held for the type of vehicle being driven, and E learner's license held. So 4 may perhaps have some correlation with the question your lordships are not considering.
That can still be.
But at this stage of the arguments, and before I'm not specially constituted bench, the lordship may consider framing this question, answering only whether Devyangna is right or wrong. And my lord, what will be the impact on the Swaran Singh judgment? Can my lord go before another constitution bench? No, that can be one way.
Well, the problem here,
it's
94 regime was in existence for last 30 years. If any new interpretation is given today, my lord, all claims in last 30 years, nobody is getting anything, my lord. Either my lord may give interpretation of prospective effect, my lord, whatever my lord is interpreting, and won't apply to claims which has arisen already. Or my lord may consider giving pay and recover, because then last 30 years, the LMV regime which was in existence and as interpreted in Devangan case, my lord, everyone was getting, insurance company was paying, my lord. And today, if suddenly last 30 years, Bharat comes to a conclusion giving a different interpretation just in case, and then all those claims would go, because owner and driver of the vehicle.
Lots of cases are pending consideration following this.
But all these, even today, all these claims.
As far as those which are pending before the Supreme Court, there are no.
Yes, but across India, across India, till today, the old regime is going on.
Pay and recover was a part of a social justice scheme, my lordship. Because by way of an amendment, also chapter number 11 is included, my lordship.
So that's on marriage, whether it should be
on marriage,
here or not, that's the question.
But the overall intention of the legislation is to actually, my lordship, to actually have a welfare measure for the victims. So it is for that purpose, prayer required, and the Swaran judgment, para 50 onwards.
I'm not for a minute suggesting that it has to be a blanket exclusion of pay and recover. If your lordship in a given scenario holds that the law is not right in Mukund Devangan, what would be the sequitur? In cases where someone does not have an endorsement, he commits, an accident happens, he will have to pay the third party claim and recover thereafter. Small people, small tour operators, we are not really concerned. But large scale enterprises, when you can really On a click of a button, you can verify the contents of a license. I've said so in my written submission. The website's also given. You can just verify. If you verify at the threshold, you nip the bud right there and then. One doesn't need to ultimately go and face the entire litigation. The owner becomes liable. If he makes that call to
You are
verify.
talking about at the stage of engaging the
Yes,
person.
my lord. At the stage of engaging
See, that might be something which would be forthcoming. But what is going to happen for the things which are already not in the Supreme
it could
Court,
be
but
prospective.
on a
Lordships may say that this judgment will apply prospectively.
Possibly, my lord.
Because technically, your lordships, when the reference order of 2022, when your lordships passed this order, had passed a direction to pay all the claims of insurance companies.
Possibly
2022
this
order is
question may
that
not
one.
arise. Only a minute. Lord, your lordships, this question may perhaps not arise.
Right, whether Devangan was right or wrong. And
Correct.
for the
I-
present, leave it at that,
I'll assist your lordships why this question perhaps may not arise.
May not arise of it.
In D, when my lord, I read license not held for type of vehicle being driven. Your lordships are examining as an interpretative process what is the correlation between 221 and 10. But in practice, when we get the license, I get the license of MV within bracket NT, means motor vehicle non-transport. And for transport, if I want to drive a transport vehicle, I'll get MV within bracket T. So, my lord, so far as this is concerned, if I am driving, my lord, a license, I have a MV non-transport, and if I'm driving transport, then, my lord, I'm not having a license, that's all. Am I clear, my lord? The fourth category may perhaps not arise because the department itself follows the practice of giving two different categories of.
Now tell us one thing, if we overrule Mukund Devangan, suppose, I mean, we have to hear the other side, we overrule Mukund Devangan, there would be cases which are pending across India today on which the entirety of Devangan would.
General trend of the tribunal.
Now, the Devangan regime has also held a field. Devangan itself is of 2017. For 6 years.
In generally,
Government made a
18.
notification.
generally
Central
speaking,
government
Your Lordship, the tribunals do not give recovery rights. Nowadays, in
No, but
accident,
forget the pay and recovery rights. What happens if you overrule Devangan to pending cases?
I just point that out. One is
law has
pay
been
and recover your lordships is one
So
part.
therefore, we'll have to still
No,
we'll have to still
My lords, I'm answering.
decide whether we just simpliciter overrule it or say that, well, this is the law which we lay down from hereafter.
It
will not apply to pending case.
Will not apply to pending
Under
case.
section
Because there'll be
150.
some element of,
Under 100 section 150 subclause 2, one of the valid defenses that an insurance company can take is that the person driving was not holding a valid
Yes,
license
that
to
doesn't
drive
matter.
that vehicle.
For-
All that I'm saying is the implication.
For
If a
prospective
licensee-
overruling, that makes no
Sorry?
difference. That's an interpretation of a statute. The defense can be taken.
Yes.
But then to overrule the judgment, we will also be able, we are entitled to say that
Yes.
will apply prospectively.
Yes, my lord.
My lord,
What's
I-
the difficulty?
What-
I'm not saying for a minute. I'm-
My lord, not.
Paul, you are saying, one second.
that's
So
a
Paul is
submission.
saying,
I started with that. It has to be
150,
prospective.
150, it's a valid defense for an insurance company to say that the person who was driving was not holding a valid license.
Yes.
The consequence would be, forget the pay and recover principle. The consequence would be that ordinarily the insurance company would not be liable to the claim by the victim of a motor accident.
My lord, the question would be, as far as that driver is concerned, he could not have driven that vehicle.
Right.
Because an insurance policy is always contingent upon
Of course, that's
the
right.
conditions contained therein. That's all. Because my lord,
But
it
defense
doesn't
will
put the
be that
question, the
you are
implication
not
of the
liable to
Devangan.
pay.
That's all that I'm saying.
Therefore, the consequence for you
Yes.
would be that you can say, I am not liable because, the driver did not have a valid license and there was a breach of section 150 therefore.
And please see, my lords, would an insurance company not be justified in saying so because someone starts employing anyone who starts driving?
We are not saying,
they are not saying
one
no.
second. We are not saying no for a moment,
Yes.
but all that we are saying is that therefore we may consider as to whether, if we decide eventually to overrule Devangan, whether that should be done prospectively.
Absolutely, my lords, I bow down to
Bring
that.
about some
Otherwise,
certainty in the law for the
clearly
future.
comes into play.
I bow down to that.
It always was this, the law always was this. Unless your lordship.
Unless prospective.
Because
Adopt
any
prospective.
declaration is always retrospective by the Supreme Court unless we say to the contrary.
As far as the pay and recovery aspect is concerned, my lord, law is well settled as on date.
That may,
All right. Now, anything more, Mr. Amit Singh, that you want to add apart from what has been argued by the others?
Your Lordship, may I also press a little bit? Just give me 2 minutes to address this issue. Because in a case, if Your Lordship's hold, I'm not for a minute suggesting that it has to be retrospective. I am submitting that it has to be prospective. But what would be the relief? Relief would be pay and recover in case of a breach. If I establish a defense under section 150, Roman 2, I am not liable technically, but Your Lordships have in Swaran Singh said that in third party claims you pay and recover. I'm not for a minute suggesting that it has to be a blanket application of pay and recover. We are here, Your Lordships, dealing with transport vehicles. Transport vehicles necessarily implies that they are from multinational organizations, educational institutes who have the wherewithal. I'm not talking for a minute that innocent third parties or innocent owners or even a small time tour operators. For instance, like HCL, they have employees ferrying them around for a particular amount of fare. Those are transport vehicles. Why shouldn't HCL or any other company who commits a breach, who employs a driver who does not have the adequate license, why shouldn't they pay at the first?
But can you not argue that in an individual case?
So, Your Lordship, that's why, because
Why does
Swaran
that
Singh
arise?
comes
But
into
Swaran
play.
Singh does not say that in every case that you have
No, it
to
says,
pay.
may I just point out? It says,
It opens up a remedy of pay and recover.
Yes.
But Swaran Singh certainly can't be construed to mean that where your, the transport vehicle was owned by, say, some big multinational, that therefore also the insurance company must pay and recover it from them.
that is what generally
right,
happens,
my
Your
lord.
Lordship. Pay and recover, that's the standard order.
It is the individual case basis still, my lord.
May I just also? Lordship, may I just point out just 2 paragraphs of
I should be settled the Swaran Singh correctness
No,
of
no,
Swaran Singh
yeah.
over here, Frank.
Your Lordship, because it has been doubted twice. May I show those orders?
There are a number of
Twice.
things which are doubted,
But you
I don't
know,
whether
I'll
we
tell
should
you
take
one
it
more
up.
thing. There are also, look, there may be valid reasons why our colleagues who have preceded us in this have decided not to decide that issue and just disposed of the whole issue and kept it open. Because ultimately the court, in such a case, you have to balance it. Suppose if you say pay and recover will not apply, or you say Swaran Singh had no basis in law, look at what happens to the ordinary victim of an accident.
Your Lordships, may I say one thing?
Proper way to do it is that
in an
in a
appropriate
Swaran Singh
case.
case, when this question is formulated properly,
Then you
everybody will address on that question. Then the court will be able to look into it and then come to a conclusion. But when the question is something else, it won't be proper also for us.
Your
At least
Lordship,
my lord may also indicate in this that actually my lord not interpreting the one of Swaran Singh. Otherwise, the insurance company will, my lord, should again.
No, we are not going to go into it at all.
Because my lord, what they will say that, okay.
Look, what we'd like
is
you to
not
do
valid,
now
so-
is we'd like to hear you on merits, on the Devangan.
Please.
We'd like you to tell us how Devangan is right.
Lordship, I have 2 more points.
Yes.
Just 2 more points. 5 minutes, not more than that. My second question, Your Lordship, is whether in the
Devrat, how long would you take?
Not much, but I'll finish today.
And followed by? Devrat, about today, where you take 20 minutes?
I'll try
You will be able to complete it
Finish it.
today.
It is possible.
Yeah, 20 minutes. He's finished today. He says half an hour.
I think 1 hour is enough for all of us.
I'll take 5 minutes.
This site was heavily insured.
But we've already paid. Whatever dues were there, we've already paid with a direction that we will not recover. Last order says so.
Their clients are safe. There's no difficulty.
yes,
They're arguing it to assist the
Out
court.
of 70, only 3 or 4 have turned up.
Yes. Pro bono.
They're all appearing, you must be all appearing pro bono, right? Your
Yes,
client
yes,
should have.
my lord.
Which is why I said, no, this is heavily insured.
So at least my lord also give a patience hearing, my lord.
No, we need to have that
We
perspective
also
also.
need,
I
we
will-
need to have a contra perspective because frankly, as you would have obviously understood,
Yeah.
we have been prima facie impressed with the submission on this side, but we are always open until the last word is said. So we'd like a contrary viewpoint.
Lordship, the other,
Yes,
just
Tell us the
Yes,
on-
Lordship, only on the relief, because I don't want to repeat the arguments.
Right.
The other argument, Your Lordship, is that when we are establishing breach under section 149(2), now section 150, Your Lordship, since Swaran Singh had said that the burden is on you, on the insurance company to establish a particular breach. That view, noticing Swaran Singh, Your Lordships have taken a different view in Pappu versus Vinod, which is at page 56 of my
That
compilation.
the insured must establish that.
Yes, Your Lordship, the initial onus is on the insured. So I'm saying, Your Lordship, in cases like
The insured is the victim of an accident caused by a person with whom he or she has no privity.
insured,
Insured,
yes,
right?
insured, the owner of the owner of the vehicle will have to prove that he has taken all adequate steps before employing a driver. Because Your Lordship, pay and recover as an insurance company, I sought instructions, not even 5% pay and recover. Just in the books, they're written off as bad debts. Hardly any recovery.
How much do you have to pay per year? Tell us that. Is there do we have statistics of, for national insurance, how much have you paid, say, in the last financial year?
For pay and recover, Your Lordship, I don't know. I mean, individual cases, I'll have to seek instructions on that. But a lot. I'm saying that at least there appears to be, because Pappu, in Pappu versus Vinod, Your Lordships were Justice.
The issue of burden of proof, etc. also. See, one of the reasons why we don't want to expand it is that we must also have an adequate representation from the other side. They are appearing for a group of people whose clients have already been paid. Now to make them argue in response to something, which really speaking never arose in their case, they have no notice of that, and we decide that and lay down this wide principle. Should we not allow it to be decided by an appropriate bench, maybe an appropriate 3-judge bench? When you have live cases,
But they appear, Swaran Singh is also 3 judges. So is Pappu versus Vinod.
The time will come, deferred, so.
And my Lord Justice Chandrachud was a part of Pappu versus Vinod. Justice Mishra, Justice Khanvilkar, and Justice Chandrachud. Because it's very difficult. Swaran Singh says that you have to establish negligence, you have to prove breach on the part of the
We understand
owner.
that that's troubling you very much.
Or as an insurance
When it doesn't arise here, you'll have to wait a little bit. Some other context we will take.
Some other matter.
I'm grateful, my Lord, for a patient here.
All right. Yes, Ms. Devraj.
I am concentrating my arguments only on the basis of section 221 and the element of weight, which my Lord, the side have argued, is not important. My respectful submission, my Lord. The weight constitute a very important elements of this act. There are too many definitions about weight. Section 2, subsection 3 defines axle weight. Thereafter, if your Lordship may kindly come to subsection 15 is gross vehicle weight. Then it's 16 is heavy goods vehicle. The heavy light is all weight. 17 is heavy passenger motor vehicles. Thereafter, lot 21 is light motor vehicle. Then Lordship may kindly have 23 is medium goods vehicle. These are all weight. the two very important facets on which the license are granted are LMV and HMV, which is light and heavy. So, in my respectful submission, the weight constitute a very important element of this act. Unlike what the other side, have stated, in the light of, what I've stated, I'll again read the section 21, which is light motor vehicle. Lordship has read so many times. Means a transport vehicle or omnibus, the gross vehicle weight of either of which, or a motor car or tractor or road roller, unladen weight of any of which does not exceed 7,500 kilograms.
12 feet of
I have circulated my written submissions, I think appear on the Lordship, please. Thereafter, I'll just keep.
Yeah, you run through it.
Just run through the
Lordship.
Chai.
I have already read section 21, 221, my lord. And section 2 also, your Lordship has seen, my lord. It's 10-2, my lord, Lordship has read. I don't want to take your Lordship again. But my lord, subsection E, my lord, this was substituted in place of medium goods vehicle, medium passenger motor vehicles, para 4, my lord, I'm reading, heavy goods vehicle and heavy passenger motor vehicles, my lord. 1994, my lord.
It is clear. Just read
It is clear. The legislative intent is clearly to replace above said classification with a single class of transport vehicles. Thus, the expression transport vehicles will include only the heavy goods vehicle, as in sections 216, heavy passenger motor vehicles, as in section 2, clause 17, medium goods vehicle, as in section 2, clause 23, and medium passenger motor vehicles, as in section 2, clause 24. Well, however, the classification of LMV remains unchanged in
On the other hand, isn't there not intrinsic evidence to show that once the legislature brought in the expression transport vehicle, it would include transport vehicles of every description?
Well, I'll take you to a very interesting, my lord, table. If your lordship may grant me liberty, my lord, it's the end of the submission.
Transport vehicles which are above 7,000.
Yes, my lord. I'm coming to that point, my lord. That table, my lord, is.
That's there in the Bear Act also.
Well, it is the end of my submission.
There is substance, yeah, there is something in it, because obviously then your contentions, transport vehicle should include all transport vehicles other than those which fall into the definition of light transport vehicles, light motor vehicles.
Lordship, can you have this table, my lord? My lord, this is actually designed for the benefit of section 41, which is about the registration of the motor vehicles, my lord. Your lordship, at the end of the submission, it is annexed. If there is a difference between transport vehicle and non-transport vehicle, that is being given by way of a table, my lord. That is the end. It is there in the screen, my lord. Lordship, may kindly see, even if the point 3 is most interesting, motorcycle used for hire to carry one passenger on pillion and motorized cycle rickshaw for goods or passenger on hire. This is also transport vehicle.
Where motorcycle with sidecar? Three.
Point 3.
Motorcycle used for hire to carry one passenger on pillion.
But the weight would be not more than 200 kgs, my lord.
Rapido.
This is also transport vehicle, my lord.
Rapido.
Lordship, please. And there are lakhs of them, my lord. Lakhs of them all over India, my lord. Everybody have to apply for a transport license.
That's the reason, that's the controversy going on.
Yes, my lord.
They contend that it should not be, we should not be compelled to take license, and government says that unless a license regime exists, the safety can't be ensured. So therefore, we don't know who will be doubling up as a transporter today, and who will take him from his residence to the office, and what happens in accident if there is an accident. So therefore, a regime where somebody is utilizing his transport vehicle for transport purposes, licenses are necessary.
Lordship,
That is what.
there is a Form 2 and Form 4, which is
Absolutely no control.
which is similar respectful submission. For such kinds of vehicles, there is a license which is separately provided for aggregators.
Yes.
Well, these are transport vehicles under the present scheme, my lord. They are run under the license of LMV. Lordship, may kindly run through this table, my lord. Motorcycle with sidecar for carrying goods, that is also a transport vehicle. Motorcycle trailer to carry goods, that is also a transport vehicle. Third, I have read, my lord, motorcycle with a pillion rider, that is also a transport vehicle. Luxury cab, three-wheeled vehicle for transport of passenger goods, goods carriers, trucks or tankers or mail carriers, power tillers and tractors using public roads. Number 8, my lord, mobile clinic or X-ray van or library vans. Mobile workshops. 10 is mobile canteens. Private sector service vehicles, my lord, that has been defined, my lord. Public service vehicles such as maxi cab, motor cab, stage carriage, and contract carriage, including tourist vehicles, educational institutions.
Mr. Devrat, we'll give you a little time tomorrow. You can conclude. After Devrat, two of you are going to argue. Between the three of you, 1 hour, we'll conclude tomorrow. Right.